Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode or video, I'd like to talk about the widow petition. So, what exactly is that? When does a widow petition come into effect, and how is it possible to apply for it? Well, basically, let's just say that you happen to be married to a U.S. citizen, and the U.S. citizen files the I-130, which is the procedure normally to be able to go forward and adjust status, or ultimately consulate processes if you have to go out of the country. And what happens is during the middle of the process, your spouse dies. Well, there's a lot of people who have decided that once they have a petition going and the spouse dies, that's it, that they're not going to be coming into the U.S. and it's over. Well, the Immigration Nationality Act has made a law and various provisions for widowers, and if you fall under certain provisions, then it will permit you to file a widow petition, and in certain cases actually convert the I-130 into a widow petition and go forward from there. Now there are some parameters that you need to be aware of in order to be able to go forward. Now, there used to be, prior to October 28, 2009, what was called a widower's penalty, or a widow's penalty. And what this was is, if you were married to a person for less than 2 years, you couldn't do the widow petition. So now, it doesn't really matter if you're married for a month or 2 months or 6 months. If something happens and the spouse dies, you'll be able to file the widow petition. Now, there is the rule that you have to file the widow petition within 2 years after the death of the U.S. citizen. So make sure that if you're going to do this, or that if the time has come where 2 years is almost past since his or her death, that you get this filed and out the door right away, because it would be a shame to miss out on the widow's petition. Since you lost your spouse, you don't want to lose the residency also. So you'll be able to file it in that regard. Now, generally the main form to do the widow's petition is on Form I-360. So the question becomes, for example, what happens if the I-130 has already been filed and your spouse dies? Well, in many cases, what will happen is, if the I-130 is pending, okay, if it is pending, then they will allow the laws for it to convert to an I-360. So the I-130 is converted to a widow's petition, and then it goes forward and is adjudicated on that basis. Now, how is pending defined? Well, it's defined as either USCIS has not adjudicated the petition, they denied the I-130, or and a motion to reopen was filed, but they have not ruled on the motion to reopen, and similar types of situations such as that. Or there was an appeal that was up at the BIA, the Board of Immigration Appeals, and the the final decision on that has not come back yet. So there's several different ways that it could be considered pending, and if your I-130 falls in any of those categories, then you are able to reopen or have it converted to a widow's petition. Now, assuming you're inside the U.S., the I-485, which is the form to adjust status, that is deemed filed at the time of the citizen's death. Okay, and there's some caveats to that as far as when it'll be, go for final adjudication, and when the I-130 will be converted and so forth. But for purposes of at least having a feel for this, you have to be aware of when the I-485 is going to be able to be adjudicated. Now, what if someone is in removal proceedings or in deportation proceedings, basically applying for adjustment at the time that the spouse dies? Well, in that particular case, you're going to want to make a motion to terminate proceedings. Then you can have the I-130 transferred over to a widow's petition and then have it go on that ground. Now, what happens if the I-130 petition has already been approved? Okay, well, it's automatically converted to an approved I-360 or an approved widow's petition. Now, children will also be able to seek the immigrant visa status or adjustment of status depending on this and depending on if their age is under 21 and they're unmarried and so forth, because most of the time what happens is the petition is automatically revoked upon the U.S. citizen's death, but the approval will be deemed to be reinstated at the time that the U.S. citizen died. So either way, if the I-130 is approved or if it is pending, there's paths on both ways in which to have it converted to an I-360 widow's petition. Now, what happens if, let's just say, for example, that the beneficiary, the living spouse, the widow, is unlawfully present or entered the U.S. illegally? What happens with the widow's petition once it's approved? Can he or she adjust status? Well, there are provisions under the immigration law that no unlawful presence is given to persons where the I-360 or the widow's petition was pending. Okay, and again, you have to look at where the I-130 was filed and get that date of when it was actually converted. And if so, then it is possible, even if they're not eligible to adjust in the U.S., to be able to leave the United States and just return, since they're not subject to unlawful presence for that time period. And then if they do need a waiver, let's just say, for example, they are subject to some type of bar for unlawful presence. If, for example, they had much more unlawful presence before the I-130 was ever filed, well, that can be filed, and the laws state that it should be approved favorably in the benefit of the widow. So there's a lot of laws that are in the widow's favor in this particular category. Now, there is one thing that will make the widow petition void, okay, or will not allow one to file it, and that's the remarrying. So if the widow remarries, you can forget the widow petition because that won't allow it to go forward. Okay, now keep in mind that if there is no I-130 or was no I-130 filed, that the I-360 has to be filed in order to begin the widow petition. Okay, so basically that is the rundown on the widow petition and what needs to be done. There's a lot of ins and outs to it, so if you have questions, give me a call, set up for a consultation, and we'll go from there. Okay, more on the coming videos.